Hey you all, welcome back to my YouTube channel Romanticizing UPSC. In lecture number 13 of polity, we learned about several topics. The first topic that we saw was the doctrine of severability. As per this doctrine, only the unconstitutional provisions of the law, that is, those constitution's provisions against the FRs or fundamental rights, shall be declared as void, and the rest of the law would continue to operate as it. We also saw certain conditions that were imposed on doctrine of severability. Then we saw the judicial review. Judicial review means the powers of the judiciary to review the actions of the executive and the legislature. Then, under the law of 13, clause 3, subclause A, we saw a question that arose. First one, that if a constitutional amendment can be considered as a law, or the second one, that if the Constitutional Amendment Act cannot be considered as a law. Then, to answer all these questions, we concluded our conclusion on the basis of 8 cases that we saw in the Supreme Court. Okay, so let's start with the first Constitutional Amendment Act. Okay, so post independence, there was a very prominent push for land reforms. Legislations made 3 laws. First one to abolish the Zamindari system, second one to do the land ceiling, and third one for the tenancy reforms. And Bihar Land Reforms Act of 1950 was passed. Here comes the 8 major turning points for the Constitution of India, under which certain amendments and changes were made in the Constitution of India. First one, we saw that after the independence, there was a significant push for land reforms, under which 3 major laws were enacted. First one was abolition of Zamindari system, second one was land ceiling, and third one was related to tenancy reforms. Now, second, in Kameshwar Singh versus High Court of Bihar case, certain provisions of BLA, that is Bihar Land Reforms Act of 1950, were struck down as they opposed certain FRs. But then Parliament made certain amendments in the Constitutional Amendment Act. The first Constitutional Amendment Act of 1951 was passed, under which the Schedule 9 was introduced. In that, there were 13 major laws. The purpose of this Amendment Act was to ensure that the land reforms can be saved from judicial scrutiny. This Constitutional Amendment Act was obviously challenged under the court under several other cases. First one was Shankari Prasad case versus the Court of India. Second one was Sajjan Singh versus the state of Rajasthan. Third one was IC Golaknath case versus the state of Punjab 1967. Then we had certain 24th and 25th Constitutional Amendment Acts of 1971. 24th Constitutional Amendment Act added 13 clause 4 and article 368 clause 3. A CAA is not subject to judicial review under Article 13. A CAA should be provided compulsorily and approved by the President. These were the changes made. And 25th Constitutional Amendment Act added Article 31C, which stated that a law made to give effect to DPSPs under Article 39B and 39C shall not be held as void on the grounds of violating the FRs under Article 14, 19, and 31, which in short gave some DPSPs more power than some fundamental rights. Then we saw Article 31C, in which the above mentioned law, if contains a declaration that it is to give effect to DPSPs under Article 39B or C, then the courts have no power to examine it if it actually does so. Okay, the 26th Constitutional Amendment Act led to the abolition of peepers, that is perks given to some certain elite classes. And 8th, we saw KESHWANAND BHARTI case, 29th Amendment. Bye bye.